Hello, everybody.
All right, and this is People v. Justin Roth, file 23-6664FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boyne County Prosecutor.
And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Roth.
All right, and have you had a chance to, well, this is sentencing on the aggravated indecent exposure, 2-year misdemeanor with the advisory guidelines currently scored at 0 to 6 months. Any additions or corrections or scoring challenges from the defense?
Your Honor, I did go through the report and I have no additions or corrections to the report, and I believe the scoring is done appropriately.
Okay, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, anything you'd like to say on Mr. Roth's behalf?
Your Honor, I think the court is probably slightly aware from a lot of Mr. Roth's motions or the things that he does, that I do believe there is a mental health issue here that causes him to do some of these activities, and it's something that I don't think he really can control. I've had a lot of exposure with Mr. Roth, not in an type of aggravated way, but through the process of this case. And a lot of times you see this with Mr. Roth is that he has trouble controlling his emotions or controlling his activity. I would ask the court to consider that. I know one thing in talking with him and reading through the report, he was concerned that the report basically reflected that he was not remorseful for what happened. In his conversations with me, he says he is remorseful and wanted the court to know that. And I would ask the court to possibly consider he's factored out at 0 to 6. He's done very well on bond. We haven't had any issues with him. Any types of violations, I would consider the court to possibly have a no jail sentence in this case. Thank you.
All right, thank you. Mr. Roth, you don't have to say anything today, but it is allowed. Is there anything you want to tell me or no?
Yeah, this past year has been tough in the legal battles I've had in Sheboygan. I put the state of Michigan as a New Mexican through a lot, and wanted to apologize to any victim if she or her family is listening. And you know, I'm struggling a lot to work on relationships in my life, and I wrote a statement, but it just taking accountability for my actions and what a lack of maturity that I've shown, and how the medicine that I have been on since November of last year has brought my energy levels up, and there's less boredom and a little bit more determination to have a career and pursue something a little higher. So hope you take that into consideration, and that's it.
Okay, thank you, sir. Ms. Goodrich, recommendations from the people?
Yes, Your Honor. The defendant is 33 years old with no prior felonies and 4 prior misdemeanors. He's listed as currently unemployed. I was disappointed to read his reaction and subsequent messaging with the MDOC agent, and just the lack of remorse or accountability for his actions, and would ask the court to follow the recommendations.
Thank you. Well, Mr. Roth, you know, you're standing before the court for some disturbing conduct, that there is an agreement that this would be a non-registerable offense, and I agree with that. And it doesn't fit under the requirements for Michigan's SORA or catch-all provisions. So you don't have to register, but you've got a prior indecent exposure case. And in this case, you're driving down the highway, exposing yourself and masturbating and positioning your car to force other people to look at it. And then even during the pre-sentence interview, you say, well, 90% of women would like that. You are so gravely wrong about that. I mean, that is just a shocking lack of understanding to me, which is consistent, Mr. Roth. You consistently display a complete lack of understanding about how the world views your behavior. How you view your behavior, I promise you, what you think of your behavior is not what other people think of your behavior. Your behavior in our county the last couple of years has been deplorable. you've gotten to know now the circuit judge. That's not a good thing. And I've gotten to know you. That's not a great thing for you, because the ways that I've gotten to know you is your behavior, which is shocking at times. And how you interact with other persons is shocking at times. How you deemed it appropriate for you to interact with an agent of the Department of Corrections and the way that you treated them, the way that you have treated my staff on occasion, the way that you have treated attorneys trying to help you. Your comment that you're very disappointed that except for your lawyer and the judge, everybody's been a woman dealing with your case shows a level of misogyny that is troubling as well. You are a deeply disturbed individual, Mr. Roth, and I don't know that you have any understanding of that. In any event, there are some financial assessments here. $130 as a crime victim's assessment, $350 in court costs. You have to comply with DNA testing and pay a $60 fee, and there's $68 in state costs. I don't think probation would work at all. Nobody in the system seems to be able to communicate with you in a way that makes any sense. So I have no confidence that you would do anything on probation to comply. You have, although the guidelines are 0 to 6 months, a pattern of sexual deviancy and statements showing a total lack of understanding and remorse. There is a cap on 90 days jail. I'm going to impose all 90 of those days with credit for 2 days previously served. That's the sentence of the court, Mr. Roth. You can appeal it if you wish by filing an application. If you want me to give you a lawyer, I would do so, but you'd have to ask me within 6 months. We're going to hand you some of that appeal paperwork. You can fill it out if you want to take an appeal, and we're going to ask you to initial 1 copy for us. And you have to serve the sentence forthwith and go with the deputies at this time. We also have people be Kason Kreft.
Yes.
24-6899FH. Or docket call, but also we have a motion to quash. So we'll go ahead and I've reviewed the motion to quash and the answer to the motion and the transcript of the preliminary examination. Go ahead and argue your motion.
Thank you, Your Honor. Your Honor, as to the motion to quash bind over preliminary examination was held on the felony charge in this case on August 23rd. As a result of that preliminary examination, the matter was bound over. The district court asserted a finding of probable cause on the allegation of fleeing and eluding in the 3rd degree, which encompasses 6 elements, which the defense is taking issue with elements categorically 4 and 5. Largely, Your Honor, the defense is asserting that there was insufficient evidence on the record below as to whether Mr. Kreft actions in the testimony that came in at preliminary examination satisfied these elements of general intent, specifically as to whether Mr. Kreft knew of the order to stop and that he refused to obey the order by trying to flee or avoid being caught. The defense provided a summary of testimony in its motion, Your Honor, that came through an attachment on the transcript as well. Largely, Your Honor, our position is that the actual evidence that came in at the preliminary examination is largely based on the testimony of Deputy Supernull and his observations of Mr. Kreft's actions that day. The defense asserts that case law here for fleeing and eluding in the 3rd degree highlights the behaviors and the actions of the driver, and those actions and behaviors that may constitute an inference that the driver knew of a lawful order to stop and then subsequently refused. For instance, in People versus Grayer, acceleration after an officer activates flashing lights can constitute that inference, Judge. And here, the testimony that came in at preliminary examination was that Mr. Kreft was essentially identified as speeding before the officer even decided to pursue him.
Right, but then it sounded like there was at least an inference that that speed increased, because then by the time the officer pulled off the pursuit, he was at 118 miles an hour. So the speed had increased during the pursuit.
That's correct, Judge, and the transcript would indicate that the speed as testified by Deputy Supernault had increased, and Deputy Supernault did not indicate via flashing lights or sound signaling for Mr. Kraft to stop until several miles down the road when that speed was identified and outside of his cone of speed detection. His testimony was based on an observation or an increase of RPMs, I believe is what he said. So our position is that the knowledge that's imputed to Mr. Kraft certainly.
Hold on a second. That doesn't make a lot of sense to me, because if the officer pulls off the pursuit once he's at 118 miles an hour, I should infer, shouldn't I, that he turned on his lights and sirens before he reached 118 miles an hour? Because you wouldn't turn on the lights and stop the pursuit at the same moment in time. So he initiates the pursuit. The speed is increasing to the point that the officer pulls off the pursuit in the interest of safety. Isn't that what I should infer from that testimony?
Somewhat, Your Honor, only in that this is two different sections of the road. So the testimony was that Deputy Supernault first observed Mr. Kraft back near Aloha Township. As Mr. Kraft was proceeding north on M33, that's the testimony that came in, that Deputy Supernault began to hear an increase in RPMs. He then began to track the vehicle for several miles without lights, without sirens, and even in the flow of traffic was passing vehicles with the bike. At the point where Mr. Kraft approached the intersection of Straits Highway and 33 is when the decision to continue following Mr. Kraft on southbound Straits Highway was when the speed acceleration was identified at the number the court has just stated,
Right,
and the lights were activated.
Well, the lights were activated near Carter Road just before Pier 33.
Right, Your Honor, as they approach that intersection.
Okay, so then after the lights are activated, then Mr. Kraft pulls up to an intersection, which presumably he couldn't navigate at 118 miles an hour,
Correct.
turns south onto South Straits Highway, and then accelerates.
Correct.
Wouldn't that be enough, even aside from his later statements, for at least a probable cause standard?
Well, Your Honor, the defense would argue no. There's several cases, although unpublished, that indicate speed is not a determining factor for inferring intent as to the fleeing and eluding, specifically in People versus Grayer, 252 Mishap 349 in 2002. That case indicates no vehicle speed threshold alone corroborates an acknowledgement of an order or refusal of an order to stop. So the defense's position is that Mr. Kraft had to assert some other acknowledgement by his actions or behaviors, like accelerating after acknowledging flashing lights, in order for that to be probable cause for that element.
Okay, and what about the statement? So once Mr. Kraft is stopped by operation of physics, then the officer approaches him, says, "Why didn't you stop?" And he says, "I was scared." Isn't that enough, at least, to get it to a jury?
Well, Your Honor, the assertion here was that Mr. Kraft had just been in a vehicle collision. He was tossed into the middle of Wing Road when Deputy Supernault noticed the cloud of dust and identified and found Mr. Kraft. As the allegation is, he approached Mr. Kraft in that position when Mr. Kraft verbalized being scared. And our position is not that he was identifying that he was scared of the officer being fleeing and eluding, but rather his statement here cannot be interpreted as what it is merely for the fact that he had just been in a traffic accident. I mean, his ability to be cognizant of what the officer was trying to relay is hard to interpret based on that limited information received at prelim.
Okay, thank you. Ms. Goodrich, prosecutor's position.
Thank you, Your Honor. I believe that People versus Grayer is being misstated or misinterpreted. It just says that the speeding doesn't have to reach a certain level. It's not like, hey, once you reach 100 miles per hour, that's fleeing and eluding. It's just saying there's no magic number or there's no magic time of the speeding, I believe is how I interpret Grayer to say it. And we agree. It's looking at the totality of the circumstances here and the decisions, the actions, the speeds, and the route which Mr. Kraft chose to take. And that coupled with his statements at the end gave enough for the court to bind over, and also for the jury to interpret what his statements mean to them when they look at the decisions he made, the speeds he went, and the decisions of the officer that once he reached with his sirens in his patrol car, marked patrol car, once Mr. Kraft reached 118, that it was no longer safe to even follow him any longer.
Thank you. Rebuttal argument, Ms. Libby?
Thank you, Judge. And I think that the speed determination in gray area is important because the allegation here is that because of Mr. Kraft's speed at the time of his, the testimony came in from Deputy Supernal, was identified, in and out of the cone of detection because of their distance apart. Also, at times when the vehicles are close together, the sirens are not activated. What we're trying to interpret at prelim was whether this defendant knew he had a lawful order to stop and then refused it. And so the defense's position here as to his actions are not discernible between a 19-year-old driving a motorbike at high speeds because he can, or whether a 19-year-old is driving a motorbike at high speeds because he's avoiding the police. And that was not distinguished at preliminary examination.
All right, thank you. Well, the standard, of course, at a preliminary examination is whether there's probable cause that a crime was committed and that the defendant committed it. And on a motion to quash, this court reviews that decision for an abuse of discretion. I can't say here that it's an abuse of discretion to bind over on a probable cause standard where the testimony was that the officer activated his lights and sirens. And then after that, the defendant increased his rate of speed. The speed got to such an extent that the officer had to pull off the pursuit in the interest of safety. And then Mr. Kraft continued at a high rate of speed, putting down his bike in some fashion. And I'm glad he survived that at those speeds. That sometimes doesn't end well. So I'm glad he's here today. And then especially the officer walks up to him and says, "Why didn't you stop?" And he says, "I was scared." I think it'd be an extraordinary thing for me to take this out of the hands of a jury based on that testimony. So I would deny the motion to quash. We probably should set this for further docket call then, the motion having been resolved. Is that correct, Ms. Libby?
Yes, Your Honor.
Okay, we'll set it for further docket call November 26th at 10:50 a.m. Okay, we'll see you then, Mr. Kraft.
Thank you, Your Honor.
Thank you.
Be safe, be well, sleep sweet, and much love.